Purchase your tracks today. Purchase your tracks today.
All right, a very good evening, good afternoon, or good morning to our listeners. We will be glad to know where you're joining us from. We want to officially welcome you to today's session, and we would be talking about employees' right, or let me say the right of a worker as stipulated in the labor law. My name is Pearl P. Tehoda, and I'll be your moderator for today's session. In due time, I will be welcoming our guest for today's session, but it will be good to know where you're joining us from. If you're joining us from Accra, if you're joining us from Kumasi, if you're joining us from Tamale, or you're joining us from WA or outside Ghana, do let us know in the comment section. We'll be glad to acknowledge you. You can also type in your location. You can also type in your name. You can say a hello to us just so we know we are live and we are audible. We'll be glad to connect with you. Okay, Zoe Junior Kekeli from Tema. Kekeli, you are welcome. Good to have you here. Let's see who else we have in the call. I want to believe I'm not here alone. Okay, so Sherry Obeng says, joining from Tema. Okay, this is a Sherry I think I know. Sherry, you are welcome. The Tema people are reigning this evening. Oh, Deborah also says, joining from Tema. Where are my Accra people? Where are the Kumasi people? Okay, from Dawa. Okay, Dawa is also on the Tema enclave. Wow. Okay, I want to see those of us joining from Tamale. Chioma, I want to believe that's Nigeria. Chioma, good evening to you. Good to have you on this call. Hey, Zoe, it's okay. It's okay. The Tema people are reigning. Okay, so Nathaniel also says he's joining from Tema. Eunice is joining from East Legon. That's Yakoba. Okay, Yuram says she's joining from Accra. So now I see the Accra people. Efia, you are welcome. All right, Ishmael joining from Accra. So we are glad you're joining and welcome. Oh, Wisdom all the way from OT. Right. Wisdom, you're welcome. Good to see you. Good to have you. It's been a while. Let's connect after this call. All right. So once again, you are welcome to today's program, the HR Decoder program, brought to you by the HR Certification Center. We are glad to bring knowledge your way every now and then. And so if you're here, I want to believe that you are already following us on our social media handles and you get to benefit from all of our learnings going forward. Today is going to be a great conversation. We want to understand, or let me say, demystify the Labor Act. We're just going to take a session of the Labor Act. And of course, if your questions do come, we will see if we can go away from that session and respond to your pressing questions just to help you with clarity on what the law says and how it is applicable in our organizations. All right. So feel free, whilst the session is ongoing, feel free to drop your questions in the comment section. We will take them in due time. And then from time to time, we would come back to you, our audience, so we know that we are live and we are learning. Once again, you are welcome. My name is Pel P. Tehoda. And this evening, I have a special guest joining us. Of course, after I introduce him, you get to understand why he's the best person to handle this particular session. Right, so I have with me Stephen Osei Kisi, who is an industrial relations expert with over a decade of experience. So Stephen has helped parties in an employment relationship by way of helping them to resolve their differences and disputes. And for those of you who are working in unionized environment, you kind of appreciate dispute resolution clearly. And that has been the core of Stephen's work. He was with the Greater Accra Regional Secretariat of the National Labour Commission, and he's now with Niche Industry or Niche Cocoa Industry as head of human resources. Stephen is also an agent facilitator with the HR Certification Center. He has been facilitating our module number 6, and module number 6 focuses on the labor law. Now, one of the things we do at the center is to dissect the Labor Act from cover to cover, because we firmly believe that you cannot be an HR practitioner, you cannot be a people leader, a people manager without the working knowledge of the employment law. It helps in putting away a lot of disputes, a lot of conflicts, and also helps you stay out of, the back and forth with the Labor Commission, people taking you to the Labor Commission. Once you understand the Labor Act and you are able to apply it, it helps you to work effectively and also help you put your organizations out of the Labor Commission. And so this evening, Stephen would help us bring some clarity on Section 10 of the Labor Act that talks about rights of a worker. Stephen, you are welcome to the HR Center, to the HR Decoder. Let's see if our audience can hear you.
Okay, so good afternoon to your good self, and
Good afternoon, Stephen.
good afternoon to all my colleague HR practitioners who are on call with us. It's actually fun to have these conversations, and I think that we would have to thank the HR Certification Center for putting this together. And so, from wherever you're joining us, Tema and Tema people, shout outs to you. Accra people outside of Accra. I see a few names that I know. Nathan, it's nice to connect again, and let's talk after this conversation. And so, yes, let's see what we can do to learn from all other persons who are on the call with us this afternoon.
Right. Thank you and welcome to the show. Stephen, let me put you on the spot. Now, you have facilitated module number 6 of the International HR Certification Program. And occasionally I would peep in to see what is happening. It feels as though people have pressing need, or let me say they have the quest, the desire to fully understand the labor law. Do you think in your practice, in your engagement with HRs, with your engagement with organizations, do you think that our HR managers are working with the law?
Okay, that's a deep one, but I would say that yes, in the general sense, you would get to appreciate that a lot of our HR practitioners work with the law. And I am saying this largely because of the not just the class experience that I've had, but also having had the chance to work with the Labor Commission in some time past. You'd get to appreciate that between now and then, maybe a little, if you take us back to maybe 10 years ago, or maybe within 10 years, I would say, well, the appreciation of the Labor Act and the labor law in itself was not that was not was not working in a very broad scope. But you would find that in current times, a lot of HR people have pretty vast knowledge in the law, particularly the Labor Act, and so yes, there is some or some good extent compliance when it comes to using the labor law.
Right. So now, if you're an HR practitioner and you're on this call, this is the time you give yourself some thumbs up,
Mhm.
because Stephen says we are doing extremely well in applying the Labor Act, especially for people who have gone through the HR Certification Center. We get the testimonials a lot where somebody will say that after going through Module 6, they now fully appreciate what it means to even craft their own policies. Because, mind you, you cannot craft a policy that is not in alignment with what the law says. So then the first point of call is for you to understand the law, that's the employment law, before you even talk about, drafting a good HR policy. So thank you, Stephen, on that. Now let's go into the heart of the conversation. So for the Labor Act, it talks about the rights of a worker. And of course, I know that there's also the right of the employer. But today we are talking about the worker. The focus is on us. And we are going to speak as workers, not just employers. Now, I have gone through, what is stated there. As scanty as it may be, I want to believe that each one of those rights are very loaded. And of course, it talks about the right of a worker would include the right to work under satisfactory, safe, and healthy conditions. Talks about to receive equal pay for equal work without distinction of any kind. And I know that in your explanations, you'll be taking us through what each of these ones mean to the worker, all right? It also talks about the right to have rest, leisure, and reasonable limitation of working hours, end period. And I know that this is where a lot of my employers, tend to go against this right. And I'm sure that you have seen it in practice and you have seen it in your line of work. But Stephen, let's stay on what, our audience want to learn. Now, if an employee, performs poorly, and poorly means that the person is not meeting targets, the person is not checking the KPI boxes, an employer can terminate them immediately. Now, I want to find out from you if this statement is true or false, or it is right or wrong. Can an employer terminate a worker immediately based on non-performance?
Okay. So I think that the catch word here is the immediacy of the termination.
Right.
Now you would find that from the little that I have come to appreciate and learn, when it comes to terminating an employee, one of the things I always tell even the students in class when they come for the Model 6 conversations, I say that for an HR, you should not be in a hurry to terminate. So, in relation to the question of whether the employer can immediately terminate where the employee is not performing well, I would say that no, or I would answer in respect that it is actually false, that you can
Right.
just terminate because somebody is not doing well. Because in the build up to the question, you were mentioning issues about performance, you mentioned about checking the KPIs. So all of these things inform the decision to terminate. And that's why I go back to say that you should not be in a haste to terminate an employee. Now, if you look at section 15, you would find that poor performance is captured in a different way when it speaks of incompetence. So if you are not performing well, then clearly you are putting yourself within the bracket of somebody who can be described as incompetent. Now, if you look at what section 15 says when it comes to the incompetence of a worker, it gives you a ground to terminate. And when you go to section 62, and because we are discussing the Labor Act, you may at some point hear me mentioning certain sections. It's just to enlighten and make the conversation more relatable. You'd also get to understand that 62 will tell you that if you are terminating based on incompetence, it would be a fair termination. However, the incompetence for which you are terminating the worker for must be grounded. And that is where, for the most part, we as HR people sometimes we fail to tick that particular box because you need to do your appraisals. You need to be sure that the person is not meeting the minimum percentage to qualify or to show that yes, the established KPIs from the start of the year is being met. So you would find that Section 15, Section 62 would then make the statement false that you can actually terminate an employee immediately based on poor performance. Because, like I mentioned earlier, poor performance must be established before the decision to terminate can be invoked. Otherwise, then you'll be finding yourself either within the law courts or any of these other employment adjudication bodies to have the issue resolved. Because, and I also want to encourage all my HR personnel on this conversation. There's an old case, an old English case, which I say that it forms part of my reading assignment literally every quarter when I'm trying to review readings around HR practice, particularly on industrial relations. And the case title is Wilson and Clyde versus English. Now, that case places a certain duty on an employer when it comes to bringing somebody in. And then we call it the threefold duty of an employer. So the first one, that you must employ competent staff. So if you are saying that I'm terminating Stephen because he is not competent enough or he is not performing, then it means that maybe from the very beginning, your steps towards bringing in the person
Yes.
was a bit problematic. The other one is that you must have the adequate materials, and then the third is that there must be proper systems and supervision. But in relation to our question, we'll stick to the first duty, which is the employment of a competent staff. And you find that I think one of the some of the models that the center, and pardon me if I sway into what the center does as well, you would find that some of the models that the center teaches towards the certification will seek to address some of these issues. I think model 2 speaks about recruitment and selection.
Recruitment selection, yeah.
Yes, I think model 1 is on HR operations generally. I
Yeah.
think model 4, if I'm not mistaken, is on HR development and retention. So if you ever get to pass through the center, you are placed in a position where a question like this, you know exactly how you're going to respond. If you are in the boardroom and board members want to know if they can just do that. And so for those of us who have not had a chance to come through the center, I feel that some of these conversations gives us more exposure in relation to what the center does. It's not just the Q&A sessions that we do, so that you can take advantage of it and then improve your knowledge when it comes to HR practice.
Right, Stephen, let's stay on the issue of termination.
Mm.
Is it enough? And this one, I'm taking you on as an HR person. Is it enough to just give a verbal warning and terminate? Or
Okay.
there are other provisions in the law that the employer must go necessarily according to or according with to terminate an employee? Because there was an issue that came to me 3 days ago,
Okay.
and it was a long thesis where the person is being terminated just at first offense. And when I inquire, the only thing that happened to him, or the only process they took him through, was to give verbal warning. Is it enough for termination to happen?
Okay. So ordinarily, I would say that that is not enough in terms, and I will speak strictly as an HR person. That alone is not enough. And if you look at what the provisions of the Labor Act says, then you would understand that it is the verbal warning alone is not adequate to substantiate the decision to terminate. Now, even before I go to the Labor Act, the first question I would ask myself in relation to the question would be, what does our rule say as an establishment? What is our HR policy? What language does our HR policy speak? In the contract issued to the worker, did we put in there that, look, Stephen, if we give you a verbal warning, it becomes a basis for which we terminate your employment? Because some of these positions must ordinarily be reasonable. Why would a verbal warning now amount to the decision to terminate? Because if you want to terminate, then it means that we have to go back from section 15 and work our way all through and then get to the point where 62 and 63 will come in to determine if what we are doing would fall within the bracket of a fair termination or an unfair termination. So when you verbally terminate, you are literally, how do I easily describe it? It's like you are trying to hide fish from a cat, and so you have locked one part of the fish in a box, and then you have left the tail outside. Clearly, the cat will come. So verbal warnings culminating into the higher sanction of I am ending your employment relationship is a no-no. If you want to have
Okay.
peace, don't do that.
So that seemed to suggest to me as though the employer or employers who give verbal warning are not doing something right, or they are trying to hide behind something. So there is reason, but we won't state it. So when you push us to the labor court or wherever, it is your word against ours because there's nothing to show that we are based on XYZ reasons and we are terminating you. Is that also fair to say that the employer is hiding behind a verbal warning?
So, so if you look at the nature of verbal warnings, ordinarily, it's a warning. It's more like a caution not to engage in a particular act. So if you are cautioning me not to engage in a particular act, it means that I still have the chance to prove myself. So when the employer says, I am giving you a chance to not do this on one end, and on the other end, the employer is saying, even though I'm giving you the chance not to do it, no, 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 don't even stay.
You
Now
see.
go. In
Okay.
any forum, the employer would be deemed to have contradicted his own self. So the worker may not have to do much to show that you are hiding something. Your action
Okay.
alone would make it easy for the other party.
Right, right. And I'm pretty sure that for those of you who have been sending your thesis to me, sometimes late night, you are on the call and you're learning. And I want to believe that the employers or the employers' representatives, I mean the HR managers, are also learning so that we can advise in most cases, our department heads and also the employers to do the right things. Right. Stephen, let's stay on probation.
Okay.
We've been accused, if I say we, employers and also HR managers, we've been accused that we are perpetrating a lot of, I want to avoid the word, but I'm forced to use
Avoid
it.
it. Please avoid it.
We are perpetrating a lot of illegalities,
Okay.
during
That's it.
that's safer, right? A lot of illegalities during probation. We tend to do a lot of things to the employee under probation. Sometimes we deny them certain rights. Sometimes we deny them certain benefits. Give us your insight on the employee under probation. What rights do they have? What can they do? What can they not do? Both in the context of the employee versus the employer.
Okay. So if you look at Schedule 1 of the Labor Act, it gives you what ordinarily an employment contract should look like. So particulars of employment, name, date, all of those. And then there's a certain requirement that if a person is going to serve probation, Regulation 5 of LI 1833 will tell any employer that if somebody is going to serve probation, you must first of all define the period for which the person is going to serve probation. So that's the first step. Now, the moment the person starts working, the person starts accruing rights, just like any other person who has been in the employment. And so, for the most part, sometimes I get into conversations and people say, "Oh, we are waiting for the person to finish probation. Then we start paying statutory such as payee." Sometimes when you are fortunate, they start paying the payee early. Then they'll say, "Oh, when we confirm you, we'll
Yeah.
start paying you social security, all of those things." That's an illegal act. I will say it and I'll repeat it again. Once the person starts work from day one, they begin to accrue rights. So you don't say because you are serving probation, I won't pay social security on your behalf. That's illegal. So once the employee enters the employment, the rights begin to accrue to the employee. So as employers, this thing of, oh, or a probation worker.
Yeah.
So I mean, no. Once the person is serving probation, they have certain rights. And that is why the regulation at Regulation 5 is saying that you are the employer. Set out the terms that you want to use to guide the probation period.
The probation period.
So I think when we teach the model 5 and the model 6, there's a part of probation that is treated to a full extent at the center where we encourage HR personnel to set out terms under probation, which would include the payment of payee and social security, because those things are a requirement of law.
Yeah.
Maybe you can say if there's a welfare scheme, when we confirm you, then you can become a member of the welfare scheme. That's your own arrangement. The law would not frown on that. But the statutories, it is irrespective of if you are serving probation or not. And so I think that from the conversation we've had now, if those of us who are perpetuating the illegality, now we know
Out.
that when SNIT gets to know that this is what you are doing, they will come for you. And I think, not even feel, I think that these things are avoidable. That somebody is in probation does not make him less of a worker than somebody who has gone past the period of probation.
So if you were not aware, now you know that you have some rights even as an employee on probation. And I want to believe that from Monday, there will be a lot of conversations with our HRs in our various offices. But I think that one thing I picked from here is the fact that we need to learn to know so that we do not sleep on our rights. The fact that we do not know, it's either we are wondering or we are thinking, is it there, is it not there? What if we take the pain to learn so that before we append our signature to that contract, we actually can tell whether we are being shortchanged or otherwise. And so I want to believe that for people who are on this call, today, but there are also deeper conversations. So when we are treating module number 6, as Stephen mentioned, we are not just looking at the employment law, which is the act, but we're also looking at the supporting legislation. I think we do the LI 1822, 1833. We also do the other ADR Act. We do the Pensions Act
Yes.
and all the other acts that come together to help you understand employment law true and true, right? So, Stephen, thank you so much for that insight. Is it, or let me ask, is there anything in our laws that says that when I am resigning as an employee, I am entitled to some form of payment from my employer? Sometimes we start calculating, oh, I've worked here for 3 years. And so when I'm going, my employer has to pay me something. Is there anything in the law that says that?
Okay. So you won't find the labor law saying that if somebody is resigning, the person is entitled to X, Y, or Z. But I think we need to understand it from this point. Resignation is a form of termination. Whether yes, you are resigning, but in the strict legal sense, you are terminating the employment relationship. We call it resignation because it is you, the employee, who is initiating it. If it's the employer, then we say in the general sense, the employer is
It's
terminating,
terminating.
whether for cause or without cause. But in the strict sense of what resignation is, it is a form of termination. And so you find that the labor law under section 18 makes provision for remuneration upon termination. So
Right.
that if I am resigning and I have accrued certain benefits based on what my contract of employment says, based on what the collective agreement says, based on what the HR policy says, then I am due it, even though I am leaving the establishment. So, typical example, maybe we have a certain employee contribution scheme that is running.
Right.
And when you are leaving, whatever you have contributed together with the employer's own is paid to you, tabletop. So that I am resigning does not mean that I'm going to lose out on that benefit. Another example I'll probably give is leave. Resigning. Yes. But if I have accrued days within a particular calendar year that I haven't exhausted, that is when the law allows the employer to now commute that period and give you as cash instead of giving you the days to go and rest.
Correct.
So you would find that section 18, section 30, that speaks on leave and remuneration on termination. In the strict sense, if you are applying it to the question of you resigning, those terms still apply.
Okay.
So I say I put in a resignation today, and my employer says, you know what, I don't think it's even worth for you to serve the notice period. Then it means that automatically my employer must pay me the salary in lieu of notice because
Right.
I am not being allowed to serve the period of notice. So you would find that in the strict sense, it is actually not the case that when you resign, you don't get anything from your employer. No. When you are resigning, sections such as 18, 30, and any other terms of engagement in your contract of employment can come to play, or even in the HR policy. There are places where the employer has put together a condition that says if you are leaving because you have worked and you are resigning, I'll probably give you a flat out payment of 3 months' salary just because you worked for me. That's what the employer has contracted to do. So
So
when the
that
employee
must be in your policy, but not it's
that
not in the law. Good.
no, so because the law doesn't speak anything on when you are resigning, pay X, Y, Z, the
Yeah.
employer can put some of these things in their policy and the law will recognize. But it is
Right.
actually not the general position in Ghanaian law that when you and you are leaving, the employer, I want to say this in our local language, in Twi, onja okwan, or
Right.
my Ghana folks will say echiose. No, it doesn't work that way when you are
Because
resigning.
we have a Nigerian on the call, we have some Nigerians on the call.
Okay,
You may
so
want to,
so for my Nigerian people, your guy no go take give you money say take go sake of you can't work for him. No, I don't
right,
think that the Nigerian labor laws and ours is not so different. They
right.
have the differences are not so much, but per
Yeah.
Ghanaian law, there is no strict requirement on an employer to pay you for resigning, but there are certain statutories that the employer must actually do,
Good.
unless the HR policy speaks a different language.
So if it's not in your policy that after working for 5 years, you're calculating about some 5 months of your salary, that is going to be paid to you, please know that the law doesn't say so. But once you put it in your policy, you are compelled to, go by that. Stephen, thank
Yep.
you. We are not done. We are taking a short break from our sponsor, the HR Certification Center, and we will go into deeper conversations. Today, we want to make sure that all employees, all workers understand their rights in the Labor Act. We'll be back.
Why do 93% of the world's leading multinational companies prefer certified professionals? Because they tend to be committed to higher standards and ethics and maintain an informed intercultural competency. Whether you're seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855.
Right, so you're welcome back. Thank you. That is the HR Certification Center announcing.
HR Certification Center commits to a higher standard.
All right, so welcome back. That was the HR Certification Center. Announce it to you, our international HR certification. We run 4 different cohorts in a year. We do the March admissions, we do the June, we also do September and December. So for our next cohort, which is the 48th cohort, we are taking off on the 12th of September. And for those who have already gone through the certification, of course, you can recommend to your colleagues in the office. We are better off having everyone in our HR team going through certification so that together we are competent enough to deliver value for the employer. And so if you're interested in becoming a certified HR, you can speak to us on 0244122855 and we will assist you in joining our next cohort. Stephen, thank you for being with us. We zoom straight into the conversation, and this is the point where it gets interesting. And so Abed just whispered to me that employers, HR managers, sometimes we sit aloof and we watch the employer again, of course, do what is not right. So, Stephen, for an employee who has been suspended for a possible offense in the office. And so, for purposes of investigation, we ask you to go on suspension, right? So that we can complete the investigation. Is that employee entitled to his or her pay? Or the fact that you're on suspension means no salary? What does the law
Okay.
say?
So before we address what the law says, maybe we are using the term suspension for want of whatever it's supposed to mean. But when you come into the industrial relations circle, and then when we go into legal conversation, suspension in itself is a punishment. So for the most part, when we say that because of investigations, we need you to be away from work, Regulation 8 of the LI 1833 actually gives us the term called interdiction. So that we interdict you because we are doing some investigations. Now, the framers of the law, they know why sometimes they put these keywords there. Because when we interdict you, we don't want you to go and stay home and become a destitute. So you would find under Regulation 8 that whilst you are on interdiction, what the employer is required to do, I think it's about 2 or 3 things. Let me try and recollect them. The first one, whilst you're on interdiction, you are entitled to 50% of your salary pending the completion of the investigation and any other disciplinary sanction or any other disciplinary process that must be followed through. Now, if your HR policy speaks a higher language, then the law will take a back seat and then your HR policy will take the front seat. By that, all I am simply saying is that if your HR policy says you are entitled to 75% of your salary whilst on interdiction pending a certain investigation, then we won't say, oh, but the LI says 50%. No, 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 no. What is more beneficial to the worker always comes before the minimum provision in statute. So that's the first one. Then the second one is that we also don't want you, employers, myself included, to take advantage of the fact that because we can interdict you in the name of we are investigating, then you should just be in the house 1 year, 2 years. When you call for the 2 years, you are getting 50% because we are investigating. No, the framers of the law didn't want that kind of abuse. So, with that good intent, interdiction is supposed to last for 6 months. Because in the world of the whole idea is that whatever you think Stephen has done, or Pearl has done, or any of our participants, let me see who I can easily remember. Priscilla, I
There's
think that's
Chioma from Nigeria.
there's Chioma from Nigeria, there's Nathan somewhere in the Dawa industrial zone. Whatever we may have done, it is a requirement under the regulation 8 of LI 81833 that that period of interdiction should not be more than 6 months to prevent abuse. So that's the second part. And then the third part is that if before the closure of the 6 months period, you are not certain that it is actually the case that Chioma or Priscilla or Pearl or Stephen may have conducted that alleged breach, then what it means is that the remaining 50% must be paid back to everybody. Is established within that same time frame that yes, what in law would say that we following the investigations, we've been able to establish a prima facie case against Stephen or against Pearl. The prima facie is just saying that there is sufficient grounds to show that you have breached a company policy. Then you are written to the effect that this is what we have discovered. Now appear and come and put up your defense. But all of these things must occur within 6 months. Then you close it. Anytime beyond the 6 months period, then note that whether your investigations are still going to go on or not, then the status quo would have to be instituted where you are supposed to pay the employee as if he is working normally. Now, there's also no room for you to extend the period of interdiction. It's 6 months, flat out. So do whatever you need to do. I think yesterday a friend called me late night that, oh, Chairman, one of our workers, he's been on interdiction for the last 8 months. I'm like, bro, what are you doing? 8 months. What are you looking for?
Yeah.
Exactly. So I just told him, go and read Regulation 8 and let's talk in the morning. This morning he called me and said, oh, bro, I've written that to the guy to come back to work. The rest, we'll see how we can deal with it.
Yeah.
So the 2 extra months that the guy has been home, the company doesn't have an option. They've not been able to establish anything against the guy. So they just have to reimburse him the last
Yes.
8 months, the 50% that was held. So that's how it goes to treat these things. When you suspend somebody, you have punished the person.
Listen.
So when you say, I'm suspending you for 2 weeks, and then after the 2 weeks, you say, appear before a disciplinary panel, I won't come. Because you have punished me already.
It's me already. Good.
Somebody who likes litigation will subject himself through the process and hope that you will terminate them. When you do, you will take an action against the company for double jeopardy. When we say that, we are saying that you have punished somebody twice for the same offense, and the law doesn't allow that. Our constitution frowns upon that as well. So just so that we don't fall, and it's a very quiet temptation for us as HR people. Oh, say I'm an interdiction, or feel and so what's the worst that can happen? Folks, no, we don't have, unfortunately or fortunately, we don't have that luxury. The law is clear. 6 months, do all of these things. Find out what you are looking for. In that same time, do A, do B, do C. And I will say that if you pass through the center, I think model 5, you will learn
Which
some
is
of
on
these
employee relations,
employee relations and health and safety. You will learn
Yes.
these things. When we are treating Model 6, which is the labor laws of Ghana, would bring attention to that as well. And so you would find that for those who haven't had the chance to come to the center, you get to appreciate that these models speaks the language of the Labor Act. It's not just the classroom experience alone. The value addition goes beyond the slides that are going to be shared because
Yeah.
the content is relatable to what the Ghanaian position is when it comes to law.
Right. The law is the law. It's my favorite statement so far. The law is the law. And
Yes.
so if you are not on the side of the law, then we don't know where you are. Thank you so much. Stephen, we will allow our audience to bring in their questions. And just by way of protocol, please let's keep it brief. I keep saying teasers because we really have been seeing teasers, on some of these things. So let's keep it short. You can type it in the comment section. I understand we are streaming live on YouTube, on Facebook, and on LinkedIn. And so just keep it brief so that our resource person can provide the answers. I heard Stephen kept mentioning the LI, that's 1833. I call it LI 1833. And also, of course, there's LI 1822. I think one of the things we've been doing at the center is that when we talk about employment law, we don't only look at the Labor Act. I think the Labor Act is just, the main document, but a lot of the explanations, a lot of the working explanations are in the LIs. And so we will encourage all of us. Once you come through the center, you get copies for free. We'll encourage all of us to look out for these documents so that we can study them properly. So, Stephen, let's go to the question from Gloria. It
Okay.
says, can an employer decide to terminate by notice and fulfill the necessary obligations as stated in the employment contract? Will that be a fair termination of the employment relationship?
Okay. So, Gloria, if it is the case that in the employment contract, there's a clear provision that says that, and this, I'm just saying this, for the lifetime of this employment, any of the parties can terminate on notice if it is in the contract. Then and the employer needs or the employee needs to just serve that notice or pay in lieu of notice and walk away, then there's no issue. Nobody would hold any party to the fact that, oh, what have you done? No, because from the beginning, it's clearly stated that for the lifetime of the relationship, when I say I am leaving, I need to put you on notice, and that's okay. If it is absent, then we don't have the luxury of saying, I'm giving you notice, go away. Because if it is not in the contract, then we have to start the process from section 15 that talks about grounds for termination. And you will find the grounds like incompetence, proven misconduct, not just misconduct, proven misconduct, ill health, all of those things, sexual harassment. So that's section 15. We are not dealing with grounds now. But in respect of Gloria's question, if it is not stated in the contract with the accompanying necessary obligations, as is rightfully mentioned in the employment contract, then when you terminate outside of it, then section 15 will come knocking on your door because you must have that ground before you start the process. Else, absent of the grounds, it will make it an unfair termination under section 63. Then you will find that under section
Stephen,
64, you have to
please hold
pay.
your thoughts.
Okay,
Stephen, hold your thoughts. Let me play the devil's advocate on Gloria's question.
okay,
So the contract says 1 month notice, right?
yes,
So let's say in this case, it is the employer who is terminating, right? So the employer gives me 1 month notice. And let's say part of the contract says, all the benefits that are due will be paid, and the employer is willing to do that. Does the employer owe me any explanation as to why he or she is terminating me? Must that be stated in the termination letter, or the employer doesn't have to state any reason for the termination?
okay. So if you look at section 63, I am not too certain of the subsection, so I won't give you the subsection so that you quote and quote me wrong. But under section 63, there's a certain obligation on an employer that if you are terminating, it must be according to a fair procedure or the terms in the Labor Act. So where you say, I'm terminating you, I'm giving you notice, I'm giving you A, B, C, D, thank you very much. Then the question would be, in your HR policy, what is the position or what is spelled out under the umbrella of termination? What is the requirement that you have placed on yourself as an employer? If your HR manual is silent on what to do on termination, then we'll come to the Labor Act. Now, under the Labor Act, we treat terminations from section 15, not section 17. So somebody takes you to the Labor Commission and you say, oh, but the contract says that we can give him notice and terminate. If your manual doesn't speak an equal language, or if it is that there is a certain variance, you would find the commission ask you that from the beginning, was that fully stated that in the lifetime of this contract? And somebody will say, oh, we didn't put it that way. Well, then you have to do more to defend your position, because in the eyes of the commission, they will go back to section 15 and ask what the grounds are, because section 63 is saying there must be a fair procedure or in accordance to the Labor Act. So if we can't find a fair procedure from your manual or clearly put out in the employment contract, then we are coming to the Labor Act. And under the Labor Act, you would see that it will tell you grounds for termination, section 15, notice on termination, section 17, remuneration upon termination, section 18. Then we come to section 62, fair termination, 63, unfair termination, 64. That's where you have the compensation, re-engagement, reinstatement. So that part under 64 will seek to correct if it is that your action is founded on unfair termination under section 63. So a lot of the time, I think you would find that if you come to the center, every facilitator will tell an HR practitioner that, folks, document, document, document. There's a reason why we keep hammering on let the policy speak. So that anywhere you just open the policy and say, this is what the policy position is. Was he made aware? Yes. Did he sign it? Yes. Yadi assembly, we are done. Because you have already signed on to that this is how these things are going to be treated. So as for termination, it is very critical. And you would find that, I think if you look at the statistics from the Labor Commission, take 10 cases, possibly 7 out of those 10 is on termination and issues arising thereof. The remaining 3% will be on other matters, will be on utilization, redundancy, but the key issues are always on termination, because that is where a lot of the problems come from. So that's how best I can respond to Gloria's question.
Right. Stephen, just when we're on Gloria, somebody decided to drop a question in my personal chat, not
Okay.
on the call. So he
Okay.
says, okay, I think it's a she. Hello, Madam Pearl. Please, I have a question for Stephen. Is it right for an employer to ask an employee to go home and change because the person is wearing unapproved uniform and then deduct the hours spent by the You see, I will not even finish the question.
Sorry, please. What's the name of her? Okay, the she.
The
Okay,
she.
Madam She. I beg you, and I will beg you for a third time. That deduction is not founded in any law in Ghana. So, Madam She, if you have your Labor Act with you, look at section 69 and then look at section 70. So 69 will talk about permitted deductions. 70 will talk about permitted deductions. 69 will talk about prohibited deductions. And that situation that Madam She just spelled out to us will fall flatly under prohibited deductions, because under Ghanaian law, you cannot impose any financial obligation on an employee for any reason whatsoever. So I have worn a uniform. Maybe it is not the prescribed uniform, but even the first question I'll ask she is that, do you have a prescribed uniform that the employee is aware of? Number one. If it is the case, it is probably right for you to say, go and change into the prescribed uniform. But the decision that because you are going to spend maybe an extra 2, 3 hours in traffic to go home and come back, we are going to deduct. I will pretend that that question wasn't asked. Please, let's not do that because the law says you don't have the right to do it. Plain and simple. Find some other way of imposing a sanction on the employee.
Yes.
But their salary there is
Yes,
protected
I was
by.
just going to say find another way of punishing the employee, if that's the right term, rather than,
Mm,
and you see, she goes on to say that nothing of the sort was communicated to the employee. You get your salary at the end of the month, and then you notice that it's short by some amount. You go and inquire, and then you were informed that it is because we asked you to go home. Dear
no,
employers, comma,
no.
please, we are begging you.
I like the comma bit.
Yes, we are begging you, be on the safe side of the law.
Yeah.
Please, dear she, ask your employer to come through the HR certification program so that we can reorient them on what the law says that is permitted. All right, so we go to Felicia. Felicia says, kindly touch on contract employees and their annual leave, especially on year fixed term contract. Okay, so I'm sure Felicia is talking about contract employees who are on fixed term contract. I think the law calls them something else, but let me allow Stephen to respond to Felicia's question.
So Felicia, one of the general position. Let me begin from that point. The general position per Ghanaian law is that every employee is entitled to the enjoyment of annual leave. It's a right for a worker under Section 10, as Madam read earlier. And so you would find that even if you are a fixed term employee, let's say your contract is every year, is a fixed term, possibly renewable every year, year on year, then it means that for every fixed term period, when we are putting together the contract, we must factor the enjoyment of leave. Now, if you look at Semila says, please, you don't touch people's budgeted salaries. We beg. Please, we won't touch. So to Felicia's question, if my contract is, let's say, 1 year, that's 12 months. You will find that in the 12-month period, the Labor Act under Section 20 says that the minimum days that an employee should enjoy as annual leave is 15 working days. So when I am putting together your contract, what I will do is that I will make a provision within that 12-month period of a 15-day period for you to enjoy your annual leave within
Yeah.
the 12 months, not outside of it. If it is 6 months, then it means that you are going to take the 15 days and divide it into two. You can't have 7.5 days. So you probably, for a 6 month contract, you may have a provision for maybe 8 days. That is a little above, that's an extra half day so that you can just meet the minimum requirement. So you look at Section 20 that says you have 15 working days as leave, and then you design your contract to suit the 15 working days so that if the person is doing year on year, you can decide to do 17 depending on the exigency of work. 17. It can be anything above 15. Nobody has a problem. But it cannot be less than 15. That point must be clearly made. It cannot be
Right.
less than 15 because he's doing a 1 year contract. No. Minimum is 15. That's what the law says.
Right. Thank you, Stephen, on that. This is from, we're referring to someone as she. We beg you, because she didn't put her name. So please pardon us if we are referring to you as she before we go into the Tony Elumilo kind of issue where they are referring to somebody by their
you,
first names.
you
All
call
right.
me you call me Mr. Elumelu, you don't call me
No,
Tony.
don't call me Tony. Yeah, you know. All right. So Jefferson is asking, follow up to she's question, imposing financial fines on an employees for coming late to work.
That's a
It's a
no-no.
no. Yeah, so Stephen says it's a no, no. The law is the law. Please, any other thing is alien to us. So Jefferson is a no, no, as Stephen has mentioned. And so, okay, Gloria is back. I don't know if it's the same Gloria, but it says, what if it is not a written policy, but a norm or a convention? I'm asking in relation to the resignation. So I think Gloria asked something
Okay.
on resignation.
Yeah.
Yeah.
So,
Okay.
so I think as a follow up to her earlier question, whether if I leave, I mean,
Yes.
should you give me something? So if it
Yes.
has actually been a norm, that
Mm,
is respected because when Kofi left, we gave
mm,
him something. When
yes.
Amma left, we did same. When Chioma left, we did same.
Mm,
How is it that
mm,
Gloria is going and all of a sudden we are forgetting that we are supposed to do same for Gloria?
mm,
Because if we
mm,
don't, by virtue of our convention, Gloria can
mm,
actually take an action against the employer for discrimination. And there will be reasonable grounds for anybody to listen to those grounds because
mm,
we have done it over time. So
mm,
it's become a part of the establishment. So it's only fair that
mm,
when somebody else is leaving based on resignation, we do as we have done in the past. Where we think we don't want to continue with the convention, then it's on
mm.
us as management to now put in a communication to say this used to be the case going
It's no
forward.
longer.
Yes.
Right. Right. But I think that, Stephen, largely, I feel that, you see, because we're dealing with human beings and we're also trying to project a certain image as employers,
Mm.
I think it's safer to document some of these things. So what
True.
you can do, state it in your policy and be sure that whatever you're stating in your policy is sustainable. If you feel it's not sustainable, please don't even put it in the policy so that somebody will take you to court for no reason. And if you're going to do it based on the norm, the convention, please give reasonable explanation so that people don't just sit and assume that because you've done it to X, technically you do it to a
Right.
Z, so
Mm.
that people can have some of these clarity going forward. But of course, if you do it for A, it is just fair to say that you must do it for B, because we are all employees of the organization and we are all working so that the company can work. Let's go back to Jefferson. So Jefferson is asking, can an employer for any reason keep an employee who has been with a company for more than 16 years? I'm not getting it, but I'm sure I'll get it. After every 6 months, they terminate and ask the employee to reapply. Oh, wow. Can an
Okay.
employer for any reason keep an employee who has been with a company for more than 16 years? After every 6 months, they terminate and ask the employee to reapply. What are the, I think I'm not getting the other side of the
So,
question.
yeah, I
So
think some part.
technical team, if you can help us project everything. Otherwise,
Yeah.
Jefferson, you may have to come again.
Yes. So if maybe Jefferson can come and open it up a little for us,
Yes.
then we can. I think the question was not complete, and then he sent it in.
Okay, so it says, is it legal to make an employee casual or contract staff for 16 years? Oh, okay. I now get it. So, Stevie, let me
All right.
explain a bit. I think this issue came up in one of our class sessions where
Okay.
a particular bank, for whatever reason, would so it's a contract, so a 6 month contract. After every 6 months you will reapply, they take you for another 6 months, you reapply. That has been happening for so many years. Jefferson, if that is the impulse of your question, please give me a thumbs up so that Stephen can respond to it.
Okay. So the law, if you look at it, has classification of workers. There's provision for casual workers. There's provision for contract or temporary workers. So temporary work is literally contract work, and then we have permanent work. Now you would find that for whatever it is worth, casual work is work that is seasonal in nature. So if the work is not seasonal, that person is not a casual worker. You don't put somebody at your front desk and say and describe that person as a casual worker. You always need somebody there. That's not seasonal work. So and this is a learning curve that you get to appreciate when you start off with model one, when they do the general HR operations. They will make you understand that front desk or certain roles within the establishment that are a routine are not considered to be seasonal work. Now, then we come to the issue of contract staff. The law doesn't have or doesn't frown on contract work. No, it doesn't. For the most part, an employer may decide that for certain roles, I'll place people who work in those roles as contract and make some other roles permanent. And for seasonal work, I'll bring in casual people. They come and do 3 months, 4 months. They go, they don't come again till maybe after another 5, 6, 7, 8 months. Then they come again. But where it is the case that you know as an employer that this work is going to take place constantly, sometimes it is to reduce the extent of obligation on an employer. So you would find that some of these relationships are kept on a contract basis. If that is the case, then it means that everything that relates to the contract must be spelled out for every period that the person is going to come in. So you would find that ordinarily for that contract staff, they may be earning a little higher than what somebody in a permanent role may be earning, because the general assumption is that maybe at the end of the next 6 months, he may not come back. So you are allowed to reapply and then you come in again. Now, there are two sides of this. There's one side that says, well, yes, the employer has the luxury of engaging on contractual terms. And then there's also the side that is saying that no, when you do this, you are literally abusing talent, or you are taking advantage of the fact that it's quite difficult to find quick employment on this side of the world. And so you are keeping these people, reducing your liability or your obligations against them, because you find that for the contract worker, your benefits may be restricted to your period of engagement. So every 6 months you start new. Every 6 months you start new. When we are doing continuity of service for the purposes of paying something, let's even say when we do a redundancy, you will find that that contract worker may be entitled to payment or a severance pay restricted to just the 6 month period. But ordinarily, they would have worked for more than 6 months if you put it all together. And so you would find that what some other employers have done to offer protection to contract staff, they will say that when it comes to redundancy, even if you are a contract staff, we will treat you like you are a permanent staff. Also, not forget that this thing that the employer is doing can be problematic some years to come. Because you see, there's a provision in the labor law that says that when somebody is with you for 6 months or more, you treat the person like you would treat your permanent staff. So if your permanent staff is entitled to medical, that 6 months contractor is entitled to same. If he's entitled to tier 3, you must do same, because the law is saying you don't become a permanent worker, but you are treated like a permanent worker. So everything your permanent worker gets, the law places an obligation on you to make sure that that 6 months, 6 months, 6 months relationship is also respected in that sense, to offer protection and to prevent, I mean, for want of a better word, to prevent abuse. I think that's how best I can try and respond to Jefferson's question. But if there is more, then we can always talk about it behind after the call.
Behind, yes. Because for me, for 16 years, I mean, if we're talking about some 2 to 3 years, it's understandable that, well, we didn't envisage that the project was going to come back to us. But now that the project has been given to us, we want you to reapply so you can stay on. But beyond 3 years, Stephen, ideally, you are just abusing it. And for me, I would use my boss's stem, test it at the law court. I'm sure a lawyer will be willing to do this pro bono. All right. So there's a question from Obed. Obed from Lene HR. Is it enough to employ someone for 6 months, have performance appraisal, the employee underperforms, and you end the contract because the staff has not been confirmed yet. So the person has been employed for 6 months. Performance
Okay.
appraisal has been done. There is non-performance, and then the contract is terminated simply because the person hasn't been confirmed yet.
Okay. So, Obed, all of these things are done within the 6 month period. There's no problem. So I would take it that within the 6 months, the person is serving probation. So if all of these things, the assessment, the appraisal, the clear indication that the person has underperformed is conducted within the 6 years, there's no issue. However, the moment we go beyond the 6 months, one day, just one day, if you terminate, it's a different language, because once the person goes beyond the 6 months, whether you write to confirm or not, in the eyes of the law, that person is confirmed. So for the most part, we tend as HR people to say, after your probation, we will do your assessment. My people, after the probation, the person automatically becomes confirmed. So if we need to do any appraisals, we are supposed to conduct that appraisal within the confine of a 6 month period, and then we are good to go. A day after the 6 months is a different conversation.
Or a day after the 3 months, that's a day after the
A day after
probation.
yes, a day after the probation is a different
Probation
conversation.
is a different conversation. All right, so that was coming from Obed from YouTube. I think there's another one from YouTube. Can an employer put in an employment contract that an employee can only go on an annual leave only after serving 12 full months with the company? Is that a fair contract term?
Okay. So Frida from YouTube, thank you for joining us from YouTube as well. Yes, it's a fair contract term, because if you look at the regulations or the provisions that regulate the enjoyment of annual leave, I think it's between sections 20 to 31, 32 thereabout. Um, Ordinarily, you should serve the full calendar period before you get to enjoy the full benefit of your annual leave. So let me just try and situate this in an example. I have given you a contract, Frida. I say that you are entitled to 20 working days as your annual leave. You have gone through probation of 3 months, maybe you're like your seventh month. Then you make an application that you want to go on leave for 20 days. Your employer would be right to say, we won't grant you the 20 days. However, if you put in an application to say you want leave for maybe 5 days, that's a likelihood that it will be granted. Why? Because 7 months into the relationship or 7 months into the year, if we take your annual leave of 20 days, then it means that what are we going to do? 7 months divided by 12 times 20. What we will get is a fraction of what you have accrued in terms of your leave, so that you can get the full one after the 12-month period. But if you are asking for 5 days and you have worked for 6 months, we'll do the prorating and see if you have done enough to accrue the 5 days. And an employer will give to you. There are employers who are not so entrenched on these things. Somebody too will also tell you that, please, I want to stick to what the law is saying and serve your 12 months. And then after 12 months, you want to go on the full 20 days, I'll readily grant it for you. But somebody will also say that so that we don't get so many of our employees being away after 12 months or after each 12 months because they are on leave, you are allowed to take portions of it based on prorated computations, or we split it into two. You take one half after you have gone the first 6 months of the year, and then you take the other half in the other 6 months of the year, and then we are good to go. When it comes to the administration of leave, once we are meeting the barest minimum, how we will turn it around is not so difficult. But as an employee, you cannot go and say, give me the full 20 days when you haven't clocked the
The
full
full
calendar
12 months.
to enjoy the full 20 days. Yes.
Right. But the law says minimum 15 days. So if your employer says 20, that's hallelujah for the employer. All right. So let's look at what Esther is saying. So Esther says, what happens when the employer suspends and states in the letter that suspension without pay? I think Stephen answered to
Yeah,
that
we
one.
spoke
So
as well. Yeah.
yes, so 50% of your pay whilst you are on
So
interdiction,
I think
right?
that for Esther's question, if we can
Let's
quickly
go
go
back
back.
to Esther's question.
Yes.
Let's go back to Esther's question. Yeah.
So for I think for what Esther is saying is that maybe in respect, so and this is me trying to think a little beyond what she has put on screen. So
Right.
maybe we've done our investigations. You are literally, we found you in breach of the company policy. So maybe the sanction there is that go on suspension, maybe 2 weeks. Okay, granted. What it means is that you are being punished for, or you are being sanctioned for the proven breach, which is
Okay.
2 weeks suspension. However, when it comes to your earnings at the end of the month, the employer cannot say that because you were not present for 2 weeks, I'm going to pay you for only 2 weeks, and then I'll take out the other 2 weeks because you were on suspension. That will be a breach of Section 69. However, if within the month there are certain entitlements you are supposed to get because you turn up to work every single day, then you would realize that when we are paying you, it will be short of the 2 weeks that you were not present. So let's say we give you 20 CDs for breakfast, 50 CDs for lunch every day. For the 2 weeks that you are away, we can't be giving you the breakfast. No. So you would realize that what will come to you at the end of the month would be short of 2 weeks of your breakfast provision, 2 weeks of your lunch provision. If it is fuel allowance, same principle, whatever benefit, you would realize that that 2 weeks you would be short of it. However, your basic as it stands will stand. Somebody will say, but you are not going to work, so why are we paying you? But I am on suspension. I have been punished. Now, this whole idea of suspension, when they were putting together the Labor Act, I think the team that went to Japan picked the idea of suspension from there. Well, in that culture, when you get suspended at work for breach, when you return, the number of friends you had at work before your suspension automatically reduces because nobody wants to be associated with a worker who has been found guilty of a breach and has been suspended. So their culture frowns on certain acts. So when you go on suspension and you come, everybody sees you like, Charlie, this guy, oh, Charlie, this girl.
Ex-convict.
Exactly. You are treated in a certain way. People shun your company for good reason. They just don't want to be associated with somebody who has been suspended before. I think the intent of the framers was that, oh, if we introduce this into the Ghanaian work environment, we'll probably get people to actually sit on their toes. But I say I'm faster. I'm not sure. I'm not sure it's working. When you go on suspension, you come. They will meet you at the car park. Hey, chairman, Akwaba. Oh, people will
You
embrace you.
see,
Hey, that he's back. You know, freedom
they would
fighter.
even do party for you.
They'll give you all sorts of names. But the strict sense of what suspension is supposed to do, I think that it hasn't caught on to the cultural setting within the Ghanaian workspace. And so the suspension, yes, but what you are supposed to get in respect of your basic remains the same. Your allowances will be short of the period that you are away on suspension.
Right, we are hitching on to 5:20. Originally, we were supposed to be closing at 5. I know anytime we have to talk about the law, we always go beyond the 1 hour. Of course, the last time we had the employment law, the free employment law session, I was telling the class that people are genuinely interested in the law, at least understanding the basic issues in the law, if not for application, just so they are aware. And we are glad to be doing this. So away from this, we also do what we call the Q&A on the labor law. That is also 100% free. But if you truly want to appreciate the labor law cover to cover, its application, and also look at how the supporting legislations work together to make you a functioning HR or people manager, we entreat you to come through the International HR Certification program. And module number 6 is fully dedicated to the labor act. And even before that, right from orientation to the time you get to module number 5, you would have covered a lot, because every HR issue comes with what is in the law. Ladies and gentlemen, we are sorry we could not take all of your questions. We are very much interested in them. Once you leave them, especially the ones on our social media handles, we would find time so we can connect with the resource person to provide answers. Otherwise, we encourage you to join our next session. Just be on the lookout on our social media platforms so that you have the link to register. And John, before we take leave of you, if you're interested in becoming a certified HR professional, either you are at the entry level of your HR career, we recommend the Associate Professional certification program for you. If you're at the mid-level of your career, we recommend the professional level for you. And for those of us who are girls at the top, those of us in charge of HR policy, those of us in charge of HR strategy, we recommend the senior professional for you. What do you need to go through this? A first degree with no HR experience will qualify you to go through the associate level. You go through 6 modules in 6 months. And for those of us with a degree and 2 years of HR experience, you go through 6 modules in 6 months. And for the senior professional level, all you need is a degree plus 5 years of HR or people management experience. Stephen kept stressing on the modules you would go through. So you go through modules like HR operations, you go through recruitment and selection, compensations management, you go through total rewards, you go through human resource development and retention. And for those who are in the professional class, which is the mid-level, which is a degree plus 2 years of HR experience, one of the key things you would do is module number 1, which is business management. So now for business management modules, we are looking at your full appreciation of the business environment of the industry you are in. We always say that you cannot be an HR practitioner when you do not understand the environment you are in. You do not understand how your business makes revenue. You do not understand how the revenue is expended. You do not understand what affects your industry, the competition, the regulations that are going on around your industry. If you do not appreciate all of this, then you cannot be positioned as an effective HR manager. And for those of us going through the senior professional level, your module number 1 focuses on leadership and strategy. Every HR manager, every HR director at the strategic level must understand HR leadership, must understand HR strategy, how to formulate, how to implement, and how to evaluate HR strategy. And these are the modules you would go through when you enroll for the International HR Certification Program. And of course, for each of the modules or for each of the certifications, you all would go through the labor laws of Ghana, and you would meet Stephen in that class. In that class, he takes the law cover to cover, he dissects it, and then he responds to all of your questions. This is all time will permit us. I want to say a very big thank you to Stephen for making time to join us. It's always an honor to have Stephen give his exposure on the labor law. And for those who care to know, he just didn't work at the Labor Commission, but he is also a student of the law. So Stephen, thank you so much for joining us. For those who made time, more than an hour, to be on the call, we appreciate the time. We will leave you with this statement. As an HR person, as an employee, as a worker, as an employer, let's not forget to keep learning, because knowledge is constantly revolving, and our appreciation of that knowledge and put it into application is what makes us, very important and indispensable in our organizations. Until we see you next time, stay safe and see you on the other side. Bye.
Purchase your tracks today.